So an agent informs a buyer that provision in a contract is very commonplace. And after explaining the clause, the agent assures the buyer that the clause does not mean anything significant. If something goes wrong with the transaction, the agent could be liable for what? So what does it sound like the agent's doing here? Let's think about this. What did he do? Basically, what he's doing is that he's violating the law by practicing law without a license. He's not there to interpret the contract and what's important and not important in a contract, because the point is that everything in a contract should be important, or else we wouldn't put it in the contract. So we shouldn't make light of or interpret or stress a certain part and say this is important, this isn't important, because everything that the person is signing is a legally binding contract and it holds them to it. So if they have a question about whether or not they should do something or not do something in a contract, technically that we should tell them to talk to their attorney about that. We're not allowed to give our clients legal advice, but we should tell them if they have a question of that nature that they should talk to their attorney. In some states, most of the contracts are reviewed by attorneys before they get signed officially, but some are not like that. So it depends. Sometimes we won't automatically have a client who's sent to an attorney for advice. And if they feel like they need it, though, we should be encouraging them to go ask a person who's qualified to give that advice. An owner agrees to pay a broker for procuring a tenant unless it's the owner who finds the tenant. Now, this is important. What is this an example of? And I'll wait here for just a second to let you guys read these over, because this is one of the most frequently missed concepts of all the students that I talk to. Everybody struggles with this one. So I'll hush a minute and let you read. Now, if you said that this was an exclusive agency agreement, you'd be right. Why exclusive agency and not exclusive right to sell? Because usually this are the two that people get mixed up. On an exclusive right to sell agreement, if I agree to list your house for 120 days, and during that time frame, if I've got an exclusive right to sell listing agreement, you sell it to somebody else or you rent it to somebody else. In this case, it's a property management agreement. I guess he finds the tenant on his own. Then you owe me a commission. You don't get out of paying the commission if you've agreed to list it with me during that time period under exclusive right to sell. Okay, no matter who sells it during that time frame, I earn my commission, whether it be me, whether it be the seller, or whether it be a co-broker, doesn't matter. I earn my commission. If, however, I have an exclusive agency agreement, that the difference between the exclusive agency agreement and exclusive right to sell is that in an exclusive agency agreement, the seller has a loophole that if he were to find his own buyer, or in this case, we're looking for a tenant, during the listing agreement, without any help from any agent anywhere, he does this completely on his own and gets the deal done on his own, he doesn't owe a commission. That's the loophole in exclusive agency. So remember, exclusive right to sell, if the property changes hands and is sold during the listing period, the agent gets paid. If an exclusive agency, if an agent finds or a co-agent finds the seller or his buyer during the listing agreement, the agent gets paid. The only way that the commission wouldn't be owed if it changed hands is if we had an exclusive agency agreement and the seller, through his own efforts, found the buyer himself and closed the deal without our help. Then he wouldn't have to pay, but he would here, even if he found his own buyer on exclusive right to sell. If an agent has an exclusive listing to sell a property and the property is then taken by eminent domain, what is the status of the listing? So in this case, it would be terminated against the agent's will. Why would it be terminated against the agent's will? Because if the government comes in and takes the property through eminent domain, then the agency agreement and the listing agreement is just voided out, because that is called an involuntary termination of the contract, right? I have no say in that. The seller has no say in that. The government has made up their mind, and it's through operation of law that I'm going to lose that listing, and there's nothing anybody can do about it. When a broker enters into a listing agreement, the broker has agreed to accept which of the following. Now, what is it? Is it going to be fiduciary relationships with the client and the customer? Doesn't look like it, because we've got a client and a customer here. Who do we owe our fiduciary relationships to? The client, not the customer. So let's look at the second one. Fiduciary and contractual obligations with the client. Yeah, for sure. Fiduciary and contractual obligations, because I have a contract. There's obligations that I have to meet in the contract. And I owe my basic fiduciary duties to this person because they're my client. Once again, obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill and care, all those fiduciary duties that we owe to our clients, plus whatever the contract says. When must a listing agent disclose his or her agency relationship to prospective tenants or buyers? Now, this one always throws everybody through a loop. When do we have to mention that we are an agent of someone? And let's break these down. Is it upon initial contact? What if I meet you at a birthday party for one of my friends and I say, hey, hi, I'm Maria. Do I have to go around saying, oh, and I represent the seller at 123 Main Street? No. We might start to talk about real estate, but I don't know that for sure. So I don't run around introducing myself as the agent of another person at every initial contact. That would be a little bit extreme. Immediately following an offer executed by the customer? Well, no, that's too late, right? The customer would have to know how I could potentially represent them before they made a decision and wrote an offer. At that point, I'm too late. So that one's not good. Whenever substantive communication is made beyond casual conversation, that's going to be the one. Because when we go from talking about the weather to talking about what's important in brass tacks, if you start to tell me your financial situation or your desires in real estate or what you're looking for, if you start to get into specifics with me, then we've kind of crossed a line, besides going from small talk about what you had for lunch to things that could be potentially things that you don't want disclosed. So I have to talk to you at that point before we start getting there about who I represent and how, so that you understand what your relationship with me is as a potential tenant or a buyer. And especially if I represent the seller, you need to know that before you start to tell me your personal information, because what did we learned earlier? That if you tell me things and I represent the seller, I have to disclose that to my clients. So you definitely need to know not to tell me things like that then. And an agent is operating as a disclosed dual agent on a transaction. Okay, so everybody knows that this person's a dual agent. It's disclosed. They follow the rules. They've disclosed. They've done what they're supposed to do. They're a dual agent and they're working both sides of the deal. They're representing to some extent the buyer and to some extent the seller at the same time. So what does he have to do? So A says he must require that the principals refrain from disclosing any material facts to him. Well, no, that would be bad. What if I say, if your basement leaks, don't tell me? No, we wouldn't say something like that. There would still be material facts that would be disclosed to this agent. It's just how he handles that information that's important. And then we say he must be obedient and loyal to both parties. And sometimes people choose this answer, because we're used to our disclosure or our agency duties, our fiduciary duties involving obedience and loyalty. But here's the problem. When we're going from being a single agent to being a dual agent, our relationship morphs a little bit, because now can I be obedient and loyal to both parties? Well, not really. I can't do that at the same time. If I'm loyal to my buyer, then I can't also be loyal to my seller at the same time, because they're trying to accomplish different goals and they're opposing, right? The seller wants to get the most for the property he can. The buyer wants to pay as little as possible. And I'm here in the middle as the dual agent. So I can't be working for both of them and giving them my complete loyalty, because one or both of them might not get what they want in this deal. But I can't put my 2 cents worth in and do anything that will harm their negotiation. I have to be neutral on negotiation and not tell either of them anything that would harm the other party's negotiation when I'm a dual agent. I must operate without a listing agreement. Well, no, that would be silly, because I've got a listing agreement, or else I'd be a dual agent. I wouldn't be representing the seller there. So that one wouldn't work. I can't represent one party's interest to the detriment of another. I can't do something for one client that would hurt the other client, and vice versa, right? If I'm a dual agent, I can't know that the seller would take $10,000 less and run and tell the buyer, because that would harm my seller's negotiation. And if the buyer tells me, oh, Maria, I'll come up $5,000, I can't run and tell the seller that, because then that would hurt the buyer's negotiation. I have to be neutral on the negotiation side of things and keep that kind of information to myself. Although a listing broker may delegate listing tasks to an employed licensee, the broker may not delegate the authority to do what? Okay, so let's break these down. Provide cooperating brokers with information about the property. He could ask one of his subagents in his office to tell other brokers what's going on with his listing. That's okay. Inspect the property for hazardous substances. Well, that's kind of beyond what we would do. That's something more of a property inspection would do. So that's not really something that we would expect. Advertise the property. He can tell another agent in his office that it's okay to advertise the property, so he could delegate that authority to one of his agents in his office. That would be okay. But it's this one. He can't delegate the obtaining and distributing compensation to another person, to another licensee. In the end, the broker is the one who has to accept the money that we're paid as commission and disperse it to the agents that work underneath of him. Remember, as a salesperson, as an agent, just a salesperson who's not the broker, we can't receive compensation directly from our client. The money has to go to our broker and then come back to us through whatever agreement we have with the broker. So that, for example, let's say that you had a client that you had just gone the extra mile for, and the person was really happy with you, and you're a sales agent and you have a broker, and the client says, you know what, I just think you did an awesome job. Here's $500 cash in an envelope for your hard work on top of your normal commission. I think you deserve a little extra. I'm not allowed to take that money directly from my client. He has to, if he wants to give me a bonus, he has to pay it to the broker, and then the broker has to give it to me. I can't receive money directly from my client. That would be against the rules unless I'm the broker. Agent Jerry has executed an exclusive buyer-broker agreement with the Andersons. So he has signed up to be the Andersons' exclusive buyer-broker. The agent subsequently places an offer with Melinda, the exclusive selling agent for the Lincolns. So Melinda is representing the sellers, who are the Lincolns, to buy their lakefront property. The offer contains provisions for the Lincolns to pay the brokerage commission, which the Lincolns agree to. So the Lincolns have agreed to pay the commission for the buyer's agent and the buyer's broker. Given this set of circumstances, Jerry owes the full set of fiduciary duties to, and who is it? And it's the Andersons, because that's his client. Doesn't matter that the compensation is coming from somebody else, the Lincolns. We learned that earlier, that it's not about who pays us, it's who we've agreed to represent. So even though the Lincolns are paying Jerry to bring a buyer to the table, the Andersons are his clients. The Andersons are the ones that have hired Jerry, and he owes them his fiduciary duties, his old car, obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill, and care. That's what he owes to them because they are his actual clients there. A salesperson without an oral or written listing agreement brings potential buyers to the seller. The seller says, you can bring me buyers if you want, but I'm not paying you a commission. The salesperson then continues to direct buyers to the property. And this guy keeps letting them in. Which of the following is true about this situation? Okay, so here's the thing. Even though this seller, for whatever reason, is letting people come through his property, he's saying, oh, I'm not going to pay you. You can bring me buyers, but I'm not going to pay you. Well, he knows that this salesperson makes their money through commission, so what's he thinking there? So the truth is that in this case, this could have created an implied agency, even though he's saying, I don't want you to represent me. And the salesperson is still doing things as if he is representing him, and he's allowing that to happen. It could create an implied agency. So let's read what they write here. Clients and agents may also create an implied agency listing based on substantive actions rather than an express agreement. For example, if a seller allows a broker to undertake certain activities toward effecting a transaction without a specific authorization, but with full knowledge and consent, an implied agency may have been created. So even though this person is saying, he's not going to pay him. The agent who's bringing the buyers may still owe duties to him to represent him if they have a situation where the person decides to buy the house, right? He's acting as if he's his agent, even though he's not been authorized to do that. All right, the agency relationship is defined by what? So what says how our agency relationship happens? Is it the law of real estate contracts, the agreement between a principal and an agent, the laws of agency, or in some state by statutes, which is law, or the realtor code of ethics? How is the agency relationship defined? And it would be in the laws of agency. In every state, there is a law of agency that defines how we should operate as someone's agent, what's expected of us at a minimum, and also how these agency relationships are created. And different states have different kinds of relationships that they allow. For example, in Florida, dual agency is illegal. A couple other states as well. But dual agency is just fine in Ohio as long as it's disclosed and consented to. So every state defines how we can operate as agents with each other. And so that's one of the things that we need to remember, that there's a law that tells us what we can and cannot do when it comes to agency relationships. The duties of a transaction broker or a facilitator include what? So let's talk about this. If I'm a transaction broker or I'm a facilitator, that's not the same as being a single agent to somebody where I owe them that old car, right? It's a lesser level of commitment, if you will, between the two parties. So one of the things that I would read here is I would say, okay, what would they have to do? And they would have to disclose material facts that affect the value of the property to both parties. If I know that your roof leaks, I've got to tell people that your roof leaks. And that's a situation where it doesn't matter whether I'm talking to a client or a customer, what kind of relationship I have with these people, I owe that to everyone. That's my basic duty. Okay. So I have to tell that sort of thing. But I wouldn't have to help the two parties achieve their respective objectives because I'm a transaction broker. I'm just there to kind of facilitate things, make sure things go smoothly. But whether or not people achieve their objectives is not really my job. I'm not in it to win it with one person on this. It's a transaction broker is more of I'm just helping to facilitate the process and make sure everything goes smoothly, but it's not the same level as a single agency relationship. Okay. Among the fiduciary duties imposed on a real estate agent is the requirement to do what? And let's talk about these things. Remember, our fiduciary duties are the things that we owe our client. Is it advise the principal against accepting an offer that is below full price? No, that's not really a fiduciary duty. That would be kind of their decision. What if it was $500 below full price? Maybe they would want to do that. Refuse offers the agent knows will be unacceptable to the principal? No, I don't make decisions for my principal. They should get to see all the offers and make up their own mind. I can give them my feedback on which one would net them more or which one might looks the most prosperous, but they're promising. It doesn't mean that I can refuse them on their behalf. I can't just say, oh, that won't work for my client and throw it in the wastebasket. I've got to show it to them. Advise a prospect that the principal will not accept the prospect's offer in order to elicit a better offer. Are we supposed to negotiate like that for our client? Maybe our client would like that offer. And if we tell him that the principal won't accept it, we've just potentially killed the deal for them. That wouldn't be good. We have to present all offers to the principal regardless of their amount. I have heard agents many times say, oh, I can't show that to my buyer, or I can't show that to my seller. There's no way. I'm not even going to present that. That's just ridiculous, right? That's not up to us to decide. We have to show them everything and let them make up their mind. We are the one, it's our responsibility to give them all these offers and let them decide what works best for them. Because what doesn't make sense for us might make sense for them. We don't know what other people's needs are. So we have to let them have the choice by showing them all of the offers. Agent Peter has an open listing with Frank. This is a good one, guys. So an open listing, we'll talk about that in a minute. So Agent Peter has an open listing with Frank. Paul is Peter's broker. Agent Perry's customer buys Frank's house. Patrick has a commission agreement with Frank. Who is most likely to be compensated in this scenario? Now, if you're sitting here crying right now because you feel like this is completely overwhelming, don't worry, we're going to break it down. Let's talk about each of these people's relationship. And I like to kind of like break it into little pieces. And I even make little notes like who's who in this situation. So Agent Peter, he has an open listing with Frank. What is that? What's an open listing? We have to know in order to answer this question correctly. And what that means is Frank isn't represented by any agent, but he said to all the buyer's agents out there that he's willing to pay them a commission if they bring him a buyer and the deal closes successfully. So he's told Peter, hey, I'm a for sale by owner. I'm an open listing, but I'm going to let you know that if anybody comes along, if you bring a buyer to me and he buys the house or he or she buys the house, I'll pay you your commission. So he's told Peter that. All right, so far, so good. Paul is Peter's broker. Good to know. Next, we have Agent Perry's customer buys Frank's house. So Frank has asked an agent to bring him a customer or a client to buy his house, and Agent Perry has done that. So if you think Agent Perry is the one who's earned the commission, Frank has thrown it out there that he wants somebody to bring him a buyer and close the deal, and Agent Perry did it. So far, he's the one that appears that earned the commission. So let's think about that. Perry, since he found the customer, is the one to get paid. But why not Patrick? Patrick has a commission agreement with Frank. What the heck does that mean? So basically all that means is that Frank has told Patrick, hey, I have this open listing. If you bring me a buyer, I'll pay you a commission. And Patrick has said, okay, I want it to be, let's say 4%. And Frank has said, sounds good to me. And they've signed an agreement to that effect. But the problem is that Patrick never brought the buyer. So it could be 2% or 50%. It doesn't matter. He didn't earn the commission because he never brought Frank a buyer. Agent Perry did. So he's the one who's the most likely to be compensated in this scenario.